Some interesting contempt cases this week. One that I think might be relevant to everything that's going on in the post office inquiry, and another one about this idea that juries can acquit even if the case is proved. But the first one, what actually happened? It was a road traffic case, and there was a quote medical expert. Now it became clear that he was just basically producing reports as his business. I think he did something like 2,000 in a year. So what happened was, to quote Jethro, the bog standard case. He prepares a report saying about certain injuries and type, causation and things like that. Goes back to the solicitors. The solicitors say, well, hang on a second, you haven't covered this, you haven't covered that, you haven't covered this, we need it to say that, we need it to say this, because, otherwise it's a pretty weak claim. So, without re-interviewing or examining the claimant, the person who's actually in the accident, the expert just amends the report and adds all that into the report. Now, this all comes out at trial in cross-examination. And while he attempts to deny things at first and prevaricate, eventually it becomes very, very clear. And he sort of says, well, yes, I just put in there what the solicitors asked me to do. So obviously the case was concluded, but what to do about this chap? Well, the judge decided that this had crossed the threshold into contempt of court. And he imposed a sentence of 6 months imprisonment, but suspended it for 12 months on the grounds that the behaviour, the contempt, had been reckless rather than intentional. But this went to appeal. He actually appealed this, which there's a great quote in another case recently that says something like, Mr. So-and-so, having escaped from the lion's den, was daft enough to go back for his hat. So he actually appeals this. And the appeal court gave some really good guidance because they said, well, actually, we've not really spoken much about, sentences for this sort of contempt. And they looked at all the factors and they said, well, first of all, we need to distinguish between is it an intentional or a reckless contempt? Because obviously there's more culpability if you are deliberately producing, a false statement rather than just not caring whether it's false or not. They did say, though, that the outcome of the trial might not be a matter. The mere fact that, well, it all came to light and you have found out no harm done, they've said, well, it doesn't matter. It's the attempt that effectively is the offence. They said, obviously, if people admit it, then, they can get credit for that. But they said it's such a serious form of offending that it has to be custodial. And they said that 6 months was too low. They said that the starting sentence should be 12 months imprisonment and that they couldn't envisage a situation where somebody had signed a false statement, whether intentionally or recklessly, that would attract a penalty of less than 9 months. So, they're clearly taking this very, very seriously. As for suspending the sentence, they said, because when you suspend a sentence, it has to be something about the offence rather than the offender. It has to be something that takes it out of the norm. The mere fact that this will be exceptionally hard or something, that shouldn't be a factor. Although in real life, it often is. In my criminal bar days, I used to get benders on all sorts of people just because of sob stories, and judges, judges are human. But in this case, they said, well, no, that is not a ground. Generally speaking, if you found that somebody has committed this contempt, then it crosses the custody threshold, and there's no reason why that sentence shouldn't begin immediately. So there you go. In this particular case, they said, having said that, this guy's waited like a couple of years to find out what's happening. We accept that the guidance, wasn't clear. We've taken this opportunity to set out the guidance now, so we don't think it's fair that he suddenly becomes the first person to find this out. Although, I think they could have done that, and I don't think that would have been appealable in any higher court. So there you go. So yeah, so he was, basically what they have now said is that, any form of rigging statements at the behest of your solicitors will, if it's dealt with by contempt, it'll attract immediate custody. Interestingly, the solicitor in this case, he actually was jailed. Apparently, I'm not quite sure what the sentence was. I think I've seen some people say 15 months, but I don't know if that was he served 15 months or it was a 3-year sentence and he only served half of it or whatever. But yeah, so the solicitor did actually end up just being imprisoned by the normal perverting the course of justice route, because you can pervert a civil trial as much as you can pervert a criminal trial. But it's going to be very, very interesting now to see what happens with the post office, because although it's probably too late to deal with this by way of contempt because of the original proceedings, then clearly, it can be dealt with the parallel way by just prosecuting for perverting the course of justice. And it's always been accepted that perverting the course of justice, by rigging statements, is again something that attracts immediate custody. But yeah, I think, and I think it's safe to say this, no proceedings are contemplated at the moment because the police seem to be dragging their heels a little bit. And I'm not mentioning anybody specifically, but I think we've all seen what some of the evidence has been in the post office inquiry, and it certainly seems to fit within this. I mean, arguably it's more egregious. I mean, again, in that road traffic case, this guy, it turned out, had been just churning reports out willy-nilly. But he was only actually sentenced for the one. They didn't look into any other ones, whereas in the post office, of course, there have been numerous cases. So that's contempt number 1. Contempt number 2. A lady called Trudy Warner. The Attorney General sought permission to prosecute her for contempt of court because it's something that you do need permission from the court to do in those circumstances. I'll do a fuller video on contempt one day because it is quite interesting, the different types, contempt in the face of the court, general contempt, how you deal with them, etc. But he sought permission to prosecute because she had held a sign up outside one of these climate protest trials saying, jurors have a right to acquit according to their conscience. So the idea is she's trying to influence this jury. Now the counter argument was, well, that is true. How can you be prosecuted for stating the truth? And there is that plaque up at the Old Bailey. I've done a really full video on the what we call Bushell's case, and I'll link to it in the end screen because it is interesting to look into what actually happened there, because a lot of the time it is actually reported incorrectly. What people say happened isn't quite what happened, but this video's me rambling long enough. So they seek permission. Now, what the court said is they said it's very, very fact-based, and the mischief they are trying to prevent is somebody tainting a jury. But they said in this particular case, she hadn't identified which case it was. She hadn't approached anybody. She had responded to requests. It appears that 2 jurors may have, acknowledged her, but there was no suggestion that she directly tried to influence them. So what they said is, in this particular case, based on these very narrow facts, and that she just held a sign, she wasn't approaching anybody, they thought it didn't cross the threshold for a contempt of court. Now, I must confess, most lawyers on either side of the divide are a bit surprised about that. I mean, some lawyers are very happy with it, some lawyers are less happy with it, but I think it's fair to say we're all a little bit surprised because, the whole point of contempt and perverting the course of justice is, like saying with the other case, it doesn't matter if it actually works or not. The offence is committed when you try to do it. But what I suppose they said here is, I mean, you could be walking down the street with a T-shirt saying that, and if you just happened to be walking past when a juror was there, you wouldn't be committing an offence. But yeah, we'll have to see. I mean, theoretically, it is actually open. The Attorney General can appeal this decision. It'd be interesting to see if they do. But yeah, before you all go rushing off down to the Crown Court to taint your favourite trials, just maybe have a read of the judgment. I'll link to it in the description because it's very, very fact-based, this. Although I do predict now there's going to be loads of people just doing similar things, on the back of this outside courts. It'll be interesting. We'll probably get lots of cases out of that, and that will set the parameters. So there you go. Anyway, as always, hope you found that vaguely useful, vaguely interesting. Sorry I haven't reported for a while. Partly I haven't seen any news, and also I've been a little bit suboptimal, but the boys have been giving me their support, so Lord Lubbock, say hello. Oh, God, I don't even have the strength to do that. And Cappy Barrister, Say hello. Oh, what's that? Oh, it's a camera. Have a sniff. Ooh, boob that snoot. So there you go. And oh yeah, all the YouTube liking, sharing, subscribing, all that sort of thing.